be seated.
I thought I might move it, but I guess not. Good evening and welcome to the finals of the 28th Wabash College Moot Court competition. This is an event co-sponsored by the Rhetoric Department and the Indianapolis Association of Wabash Men. My name is Jeff Drury. I'm Associate Professor in the Rhetoric Department, and I was also this year's organizer on campus of the event. We had this event over 3 days. We had a competitive preliminary round that featured 30 student competitors. And in this signature liberal arts experience, the students tackled a challenging legal problem. They read it thoroughly, they developed cogent arguments, they exhibited oral advocacy skills, and they went under intense questioning by 24 alumni, faculty, and community members. They did this all as an extracurricular activity, and they did it starting at 8:30 a.m. on Saturday. You can imagine the toll that takes. From the preliminary participants, 12 semifinalists argued again on Monday night, and you see before you the 4 finalists this evening. Before introducing the advocates, I would like to offer some thanks for this event. First, to the students, alumni, faculty, staff, and community members involved in putting this on. I especially acknowledge Scott Himsel, John Pachter, Matt Griffith, Seamus Boyce, and case writer Jane Ann Himsel for their dedication to the event. Josh Kramer, class of 2023, was particularly helpful as a student assistant this past Saturday morning. Additionally, numerous staff, including Julia Phipps, Amber King, Alumni and Parent Relations, Bon Appetit, Brandon Rash, Campus Services, and others, helped make this event possible, and a full list of acknowledgments is in the program book that you picked up on your way in. Please join me in recognizing the contributions of these people. Our program this evening will proceed as follows. I will introduce the 4 finalists, and then Matt Griffith will introduce our judges. Each speaker will have 12 minutes to present his case. First we'll hear from the petitioners, then we'll hear from the respondents. During that, they will answer questions from the judges as those questions arise. The judges will then confer in the green room there, and then come back out and announce their decision. We will ask the participants to take a photo immediately afterwards, but if you're here to congratulate and celebrate them, we would ask that you wait out in the lobby, and they will join you once we conclude the photography. So let's get on to the participants. Tonight, Vasilios Antonopoulos and Cooper Smith represent the petitioners, the United States of America, in this appeal. Vasilios Antonopoulos is a senior from Tinley Park, Illinois. He resides in Rogie Lodge and is a political science and PPE double major. His activities include pre-law society, political science society, barbell club, and cooking club. After he graduates this year, he plans to take a gap year before going to law school. Cooper Smith is a junior from Sellersburg, Indiana. He lives in Plager Lodge and is a double major in history and political science with a minor in Spanish. He's involved with the Bachelor and the Pre-Law Society. He's a writing consultant at the Writing Center, and he works on cases of wrongful conviction with the Innocence Project in Florida. He also plans to pursue law school post-Wabash. Congratulations to Vasilios and Cooper. Behind me, we have Andrew Hollingsworth and Jacob Goodwin, and I apologize for blocking them. They represent the respondents, or Blue Jones. Andrew Hollingsworth is a junior from Camden, Indiana. He's a member of Phi Kappa Psi and is a religion major with a minor in classics. He's currently active in his fraternity and is a member of the rugby club. After Wabash, he too is interested in law school. And finally, Jacob Goodwin is a junior from Indianapolis, Indiana. He lives in Rogie Hall and is a political science major with minors in philosophy and religion. He's involved on campus as the Bachelor Opinion Editor, the CIBE Senior Consultant, President of the Dork Club, Vice President of the Pre-Law Society, and Vice President of the Student Senate Constitution, Bylaws, and Policy Review Committee. No surprise, he too is planning law school after Wabash. Congratulations to Andrew and Jacob. At this time, I will And tonight he will introduce our judge panel.
Good evening. I want to start by acknowledging that I have really big shoes to fill this evening. Normally, Professor Scott Hensel's role is to introduce the judges, and he had a family matter he had to attend to out of town. But he deserves a tremendous amount of thanks and recognition tonight for his role in the court. I won't do him justice tonight, I'll do the best I can. And his wife, Jane, who authors the problem that this has for the past several years. They're wonderful supporters of the program. I really appreciate everything they do. Professor Drury, amazing job this year. I want to thank you. I saw Seamus, Boyce, thank you, Seamus. And John Packer, Shirley Johnson.
You can have him.
Oh, okay, but he got programs here. Thank you, John. I want to make one other acknowledgement briefly. Professor Joe O'Rourke passed away, and in the mid-90s, when I came to Professor O'Rourke in this building to start Moot Court, he was a huge supporter. We wouldn't have Moot Court without him, and it's sad that he's passed. Now, on to the introduction of judges this evening. If you're going to have a case on jury trials involving criminal law, this is not a bad panel to have. Our Chief Justice this evening is the Honorable Christopher Goff, who has served as a justice on the Indiana Supreme Court since 2017. He was born in Wabash, Indiana. He graduated summa cum laude from Ball State in 1994, and he earned his law degree from Indiana University Maurer School of Law in 1996. Justice Goff's preparation for the bench included private practice in criminal defense, domestic relations, personal injury, and small business matters. He served as a public defender and also served as the Wabash County Superior Court judge for 12 years. Justice Goff has improved and helped the courts, the bar, and the people that our courts serve in so many meaningful and important ways. And his many accomplishments and successes have been recognized through several awards and public acknowledgments. This brief introduction cannot possibly do Justice Goff the credit he deserves as a community leader, lawyer, and jurist. And so I would encourage you to read his fuller bio in tonight's program. Please join me in thanking and welcoming Justice Goff. Our second Moot Court final round judge this evening is the Honorable Robert R. Alteis, Jr. My wife happens to be a judicial officer, Judge Alteis. She says hello, and you're one of her favorite judges. Judge Alteis has served on the Indiana Court of Appeals since 2015. He earned his undergraduate degree from Miami University, Oxford, in Ohio, and he obtained a master's degree in criminal justice administration from the University of Central Missouri, and then his law degree from the University of Missouri, Kansas City School of Law. He began his legal career handling felony cases as a deputy prosecutor in Jackson County, Missouri. He later practiced civil law both in Kansas City and then in Indianapolis with the firm. In 1994, Judge Alteis returned to prosecuting criminal cases. His experience in criminal law matters is remarkable. These numbers are just mind-numbing for me, having just done a handful of jury trials. As a prosecutor for the Marion County Prosecutor's Office, he tried more than 100 major felony jury trials. That is amazing. Including 25 murder cases and countless bench trials. As a Marion County judge, he presided over 250 felony jury trials, including 75 murder trials. That is a lifetime's worth of work right there. And that number includes 7 death penalty cases, significant for this evening. Apparently, needing or deserving a break and some rest, he moved in 2013 to the civil division of the Marion Superior Court. But he never got that well-deserved break because then Judge Alteis served as the presiding judge of Marion County Superior Courts from 2009 to 2011. As a Marion County judge, as the presiding judge, he was responsible for administering all of those courts, and that included 850 employees and a budget of $50 million. That is a big job indeed. Judge Alteis has demonstrated his leadership as a lawyer, judge, and community leader in many other ways, and his list of accomplishments, assignments from other courts, and his accolades are listed in tonight's program. So I would encourage you to read more about Judge Alteis' bio. Please join me in thanking and welcoming him to Wabash Moot Court. Josh Winkler, welcome home. It is our tradition to have on the panel for the finals a lawyer alumnus. Sometimes that lawyer alumnus is a judge, but there's always a lawyer alumnus on the panel. And so Josh Winkler is our alumnus this evening. Josh Winkler is a partner at the Indianapolis law firm of Barnes & Thornburg. He graduated from Indiana University Maurer School of Law in 1988. But more importantly, he graduated from Wabash in 1985. He left the year I arrived on campus. From 2014 through 2020, he served as the United States Attorney for the Southern District of Indiana, and as such, he was the Chief Federal Law Enforcement Officer governing the 60 counties to the south. He also served as an Assistant United States Attorney in the Southern District before that, and then before that, he served as an Assistant Prosecutor in Kent County, Michigan, where he prosecuted violent crime. He has tried more than 50 jury trials, which is a lot of jury trials, in both state and federal courts, and he's argued over a dozen cases before the Court of Appeals, the Seventh Circuit Court of Appeals in Chicago. We want to thank him for being the alumni representative this evening. Please join me in welcoming him home. Finally, it's our tradition to have a member of the faculty serve on this panel. That's one of the great things about Moot Court is we bring together those three central components of Wabash community: the faculty, the students, and the alums. And so this evening, we're lucky to have Professor Sharima Gelman as our fourth Moot Court jurist. She's the Daniel F. Evans Associate Professor in the Social Sciences, and she's the chair of the Political Science Department at Wabash. She's taught here since 2012. She earned her undergraduate degree from Hunter College of the City University of New York, and she earned her master's and PhD in government from the University of Virginia. She's the author of a recently published book, The Civil Rights Lobby, the Leadership Conference on Civil Rights and the Second Reconstruction. Her research and her teachings range widely, and she has taught courses on a number of different subjects, mostly in American politics, government, civil rights, and the prohibition movements. Her bio tonight's program also is more robust than this brief introduction would allow. Please join me in thanking the professor for her participation tonight. I'm going to turn the podium. Your Honor, the court chooses.
Thank you. Well, good evening. We are here tonight in the matter of the United States of America versus Blue Jones. Representing the United States of America are Vasilos Antonopoulos and Cooper Smith. And representing Blue Jones are Andrew Hollingsworth and Jacob Goodwin. Good evening, gentlemen. Petitioner, call your case first. Go ahead and present your case.
May it please the court. My name is Vasilos Antonopoulos, and I represent the petitioner in the United States of America in this appeal. I will be handling the first issue in this matter, whether or not the Court of Appeals erred in vacating the holding of the trial judge, while my partner will handle the matter of whether or not the Court of Appeals Appeals erred in vacating based on whether or not the Tocqueville murders were relevant. We argue that based on the evidence presented, the Court of Appeals shouldn't be vacated. I make my case based on two key points. First, the trial judge fulfilled every responsibility he reasonably could under the standards referenced by the Court of Appeals. Second of all, even if the court did, if this court were to uphold the holding of the Court of Appeals, then it would create an unreasonable standard that would bear heavily on future juror selection processes.
First, juror selection processes just for death penalty cases or jurors in general?
In general, Your Honor. Taking the first factoid first, the judge in conducting this voir dire asked a very in-depth 100-question questionnaire of almost over 1,000.
Is content-specific questioning during voir dire constitutionally required? And I anticipate the answer to that question will be no. And I'd like you to tell me why not.
Well, yes, Your Honor, I do believe the answer to that question is no.
I figured you'd say that. Can you tell me why?
I believe we state that on the grounds that then the matter of this case does not revolve around whether or not, or of any case, does not revolve around whether or not the jurors have heard or have.
But the defendant's entitled to a fair trial.
Mm-hmm.
Right. The Constitution guarantees that.
Yes, Your Honor.
At least you concede that he gets a fair trial, right?
Yes,
You
Your
concede
Honor.
that. That's the Constitution says he has to get a fair
Yes.
trial. So why is it content-specific questions to jurors during voir dire or fair trial, particularly in a death penalty case?
Your Honor, the key issue in selecting a juror is not what they have heard or seen, but whether or not they can set aside what they have heard or seen. So while asking many content-specific questions, already important to selecting jurors across the process is not the final say or not the final bill that the selection process has to revolve around. Ultimately, only the juror knows whether or not he or she can set aside what they have heard for the trial, where they have heard it, and can properly assess the facts presented to them in the case. Answering or asking hundreds of questions revolving around what they have heard or seen would only complicate the trial unnecessarily and would override the balance between probative cause and the risks of undue influence in the jury selection process.
Ordinarily, I would probably agree with that, but in this particular case, voir dire took something like 3 weeks, didn't it?
Yes, Your Honor.
And there are not 1,100 jurors who showed up or something thereabouts on the first day of voir dire.
Yes, Your Honor.
And so why is it reasonable for us to take that statement that this was overly complicated in this particular case? Aren't we left to allow the jurors to decide for themselves whether or not they heard something that was just so terrible that they couldn't set it aside? Should that be left to the judge in this particular case, given the way the Court of Appeals and our federal system exercises supervisory control of the trial judge?
Yes, Your Honor. It should be deciding whether or not a juror can stand should be the judge's responsibility. And the judge did fulfill all of his responsibilities under the Petitioner's standards referenced by the Court of Appeals. And by any reasonable standard, he asked the jurors a 100-question questionnaire, as I had alluded to earlier, also asking numerous questions on the content of what they had seen, as well as the source of where they had seen that information.
How would the content-specific questions complicated things? Wasn't it already pretty complicated to 100 questions? Why would 100, 2, or 3 make it that much more complicated?
It was complex, Your Honor, and in instituting a questionnaire that is already so complex, it is difficult to justify adding even just 1 or 2 more questions, especially when the risk of undue influence is already so high, especially with such a very widespread and very complicated case. And asking just one or two more questions, it would exponentially increase the amounts of, or the risk of undue influence without adding much probative gain to the
How would the content-specific questions create undue influence?
It could potentially lead the jurors, Your Honor, to question what they had seen and to question, keep in their minds more the information they had seen instead of considering what they will pick up in the trial later. This is a very large risk, especially in a case such as this, with that has that information circulated all over the country across multiple different avenues. Furthermore, in instituting such a questionnaire now and in upholding it, it would create a very difficult standard for future juror selection processes to be carried out.
I'm concerned the Court of Appeals opinion seemed to weigh heavily some representations or assurances they felt they received from the trial court when they affirmed the trial court's decision to not grant change of venue. That request was made multiple times. Why should we not share that same concern?
Your Honor, the trial court judge did promise that he would conduct a very thorough voir dire when refusing the defense counsel's request to change venue. And we believe that, as the facts show, he did indeed conduct a very thorough voir dire, or as thorough as he possibly could. Once again, it is solely up to the jurors to determine whether or not they can stand trial in such a case, which is why the main turning point of this case hinges on is not what they had seen or where they saw it from, but rather whether or not they would be able to set it aside. Again, the judge asked all the jurors what they had seen. He asked them numerous questions based on the content of what they had seen, where they had seen it from. All this information was available to the judge and both the defense counsel leading up to the case.
So all defense counsel wants to do is they want to be able to ask those same kind of questions. Is that correct?
Yes,
Is
Your
that what
Honor.
they were asking for? I think what you're saying is the judge did his job, and that the definitive question under this case is whether or not they can set aside any opinions they had formed based on what they had seen and judge the case solely on the evidence that was presented before them. Is that your point?
Yes, Your Honor.
I'm always curious about standard of review here. We're trying to second guess other judges. And the standard review we've been given is clear error. Do you agree with that standard of review? And how much weight should we give to the trial, the district judge's finding that it wasn't fair and impartial jury that he's selected?
Your Honor, ultimately, the trial judge should have most of the weight in determining whether or not the jury selected.
Why is that? Why would you give a little more weight to the trial judge than the Court of Appeals?
The trial judge had the most immediate access to the information and conducted many of these interviews himself. He knew the facts of the case much more intimately than the Court of Appeals did and conducted the whole process from the start. He was the one who promised himself that the change of venue would be unnecessary due to a thorough and wide-reaching voir dire. So, from that perspective, he should be given the most deference in selecting the jury or determining which jurors should be disqualified for selection. In doing so, however, in supporting the Court of Appeals, however, a very interesting conundrum is brought up in that it creates almost an unsatisfiable standard. Once again, it is impossible to know whether or not a juror from the outside can stand trial or can stand on a jury. Only they themselves know whether or not they can adequately dismiss any prejudicial facts or opinions they held beforehand.
Will there be more questions that be useful for helping to determine or helping to figure out which jurors should be on the jury?
More questions are always helpful unless they start to tip over the balance between undue or unnecessary influence and probative cause. In this case, we have already, or every juror has already gone through a very laboring 100 question questionnaire, surveying what they have heard about the case, what they know about the case, what they have experienced about the case. Adding more questions on top of that would risk tipping into more undue influence territory, especially when there is already so much information available on what they have seen and whether or not they can be disqualified.
Should it matter to us that this is a death penalty case rather than a shoplifting case, for instance? I mean, if we reverse the Court of Appeal and uphold the trial, Floyd will be taken to Terre Haute, Indiana, just up the road, and the United States Marshal and the warden will administer a lethal dose of a medication that will take his life. The government will effectively kill this. Should that matter to us? We're doing this?
The nature of the case, Your Honor, definitely implies that more deference should be paid to this case. However, we argue that the trial judge did everything he could in his due diligence to fulfill that obligation. Once again, he asked a very grueling 100 question questionnaire. He surveyed over 1,000 prospective jurors. He asked them in-depth questions about whether or not they could set aside what they believed and what they believed in particular. The judge fulfilled reasonably every obligation. May I have a few seconds to conclude my point, please? Thank you, Your Honor. The judge reasonably did all he could to fulfill this promise. And in doing so, I respectfully request that the Court of Appeal, or that the Court reverse the decision of the Court of Appeals. Thank you.
Thank you, Mr. Antonopoulos. Mr. Smith, issue 2, please.
May it please the Court. My name is Cooper Smith, and I represent the petitioner. The district court judge acted within his discretion and according to this court's precedent when he ruled that the evidence of the Tocqueville murders was excludable from the sentencing phase of Mr. Blue Jones's trial. The Court of Appeals should have let that verdict stand. Instead, based on an erroneous application of abuse of discretion review, the Court of Appeals vacated and remanded respondent sentences, and we ask this court to reverse the Court of Appeals. The judge, under this court's precedent in Sampson, concluded that the evidence of the Tocqueville murders rationally had low probative value, and that probative value was outweighed by a very serious danger.
So, Mr. Jones, I'm concerned about a fact that I think is related to the concern that was just expressed by my colleague, and that is we've got the ultimate penalty here, and we've also got an defendant who is very young. How old was Mr. Blue at the time this took place?
I believe he was in his early 20s.
And the record indicates that there was something about the relationship with his brother in the nature of his home life that made him pay particular deference to his brother. And so when a court like ours is asked to determine really the legitimacy of the ultimate sanction, why should these factors not be important to us? Why should they not weigh when we're deciding whether or not there was an error that really jeopardizes the integrity of the proceeding?
Well, Your Honor, the fact that this is a serious death penalty case is not lost on the government, nor is the fact that respondent placed 2 pipe bombs behind a row of children. The fact of the matter is that Aqua's statements are so incredible, so unbelievable, that they tell us very little, if anything, about the nature of the relationship between Green Jones and Blue Jones. And it's
relied upon by the government to secure a search warrant?
Yes, Your Honor, and if you'll note in footnote 24 of the brief, the government, there's a distinction between Aqua's statements, which the government endorsed, and the statements Aqua made that he did not endorse. If you note in footnote 24, the government endorsed the following theory from Aqua, that Aqua and Green together planned 3 robberies. Aqua and Green together committed 3 murders. and Aqua and Green together cleaned up the scene. The government never endorsed the unbelievable statement that Aqua made, according to his own interest, that Green forced him along, yet somehow also allowed Aqua to stand outside while Green committed the murders. The government never endorsed the part of Aqua's statement that the respondents wished to use as mitigating evidence, and the district court judge rationally concluded under this court's precedent in Sampson that Aqua's statements had little probative value, and that was outweighed by a high risk of confusing the jury.
Mr. Smith, I'm very troubled by, and I'm not sure how much it matters, but the government's decision here not to give the defense the 302, the FBI report, and Aqua's confession to take. That's just clearly wrong. It's clearly wrong.
No, Your Honor, I don't think that's the case, and that's not what the district court judge concluded, even applying this court's precedent in Smith v.
Why are you
Kane.
blaming the district court judge here? It's the prosecutor's obligation to turn that evidence over to the defense. You didn't do it. That's clearly wrong.
Yes, Your Honor. Yes, Your Honor, and the district court judge here reviewed this when the respondents asked him to, and he determined that there was no Brady violation. But more importantly, to answer your question more directly, the FBI has thousands of these 302 statements, many of which will never be involved in charges, let alone in trial. The government, at the end of the day, has to determine what is material, what isn't, what is in, and what is out. But in this...
This is clearly material. I mean, how do you say this is not material? I'm just puzzled by this argument. I'm not sure it's going to change my mind on the case, but I'm puzzled that the government would take this position, that they wouldn't just give this to the defense. Maybe evidence comes in, maybe it doesn't. Why not give it to the defense and let them decide? I mean, this is crazy.
Well, Your Honor, the reason that Aqua's statements are immaterial are twofold. The first is that the nature of the crime was significantly different from the Yellowville Marathon bombings facts, but more importantly, the nature of the relationship between Green and Aqua was significantly different from the nature of the relationship between Green and Blue. So even if we accept Aqua's statements to be true, Aqua told the FBI that Green convinced him to join a robbery. It was not intended to be a murder. But then Green turned murderous, and though Aqua felt forced, if he is to be believed, he still somehow found a way out. He chose to wait outside while Green did the killings. And then Aqua, if he is to be believed, went back in and helped clean up the scene. But Blue's relationship with Green is significantly different. What Blue did was he left Green. He is seen on tape leaving Green immediately before the bombing, and on his own, placing the bombing behind the row of children. And in the manhunt, we see further evidence that shows that Aqua and Green's relationship is significantly different. The fact of the matter is, Blue ran over Green. If the respondent's theory is to be believed, then Green's force of influence over Blue should have ended the moment Blue ran over him with his Honda Civic. And what did Blue do after that? He continued to shoot at the police and throw pipe bombs at the police, and he hid in a boat, showed no signs of remorse, and in fact wrote a manifesto justifying his actions.
Help me out here. Can I conclude that there was a Brady violation, that the evidence should have been turned over to the defense, and you could still win?
Your Honor, if this court holds that there's a Brady violation, then there was indeed a Brady violation, if I'm hearing your question correctly.
I'm asking if we conclude that, can you still win?
Your Honor, I believe that if this court concludes that there's a Brady violation, then the respondent is entitled to vacated and remanded sentences, so affirming the Court of Appeals. But the petitioner, rather, is not asking this court even to hold that there was no Brady violation. The petitioner is asking this court to side with the district court judge who made this determination. The district court judge is the only one of us here who reviewed the 302 statements in camera. None of us did. We can hear what he said about it, and we can see what the Court of Appeals had to say about it. But the district court judge is the only judge who decides facts and law. The district court judge is the one who looked all these jurors in the eye. And that is ultimately what this comes down to. This comes down to a matter of judicial deference and respect for the important role that district court judges play in our system. And here he concluded under Smith v. Kane that there was no Brady violation, that the 302 statements were immaterial because, under Smith, the other evidence in the case was so overwhelming that there was no reasonable possibility of a different outcome, even had the excluded statements been included.
Does the district court judge's ruling here give the government of the United States of America some type of safe harbor of not bringing those statements and reporting over?
No, Your Honor, the district court judge's ruling doesn't necessarily mean that this court has to side with him or anything, but what it does mean is that what the petitioners are asking for here is due deference to the district court judge and his findings here. So ultimately, the petitioners respect the dual roles that this court has. First, this court obviously has to decide the specific dispute at hand, but this court also has to decide this specific dispute in a way that sets effective and efficient precedent.
Will help you with that, because we're talking about the issue of sanction only, are we not? Again, we're talking about whether or not this penalty is appropriate for this offender.
I'm sorry, Your
We're
Honor.
talking about whether death is on the line or life imprisonment.
Yes, Your Honor.
Possibility of parole. And so given that sanction, why should we not, in setting precedent for the entire country, concern ourselves with the fundamental fairness of that process? Why should the jury not have had that information and been allowed to make a fully informed decision about whether or not the ultimate sanction is appropriate?
Your Honor, we absolutely should care. Petitioners don't say that we should care any less because this is a death penalty or anything of the sort. And it is true that mitigating evidence is already a very low standard reflecting the severity of the death penalty. But what we see here is what the district court judge ultimately concluded, which was that this evidence should not have been submitted to the jury because of the low probative value and, more importantly, the high risk of confusing the issues, of creating a mini trial of these unbelievable statements within a trial for a different defendant. Ultimately,
So, Mr. Smith, let me go back to that. You started your argument off by saying the judge found that the prejudicial effect outweighed the probative value. What was the prejudicial effect? It was entering this evidence.
So, Your Honor, under Sampson, one of those dangers is the risk of confusing the issues and this. I see my time has expired. May I briefly answer the question? So, the real issue here is is adding this unsolvable murder. There are only 5 people at Tocqueville. The 3 victims, Aqua and Green. All are dead. There is no capacity for cross-examination, which is completely different. That's a key distinction from the rest of the mitigating evidence. And that was the reason that the district court judge, acting according to this precedent, was correct. We ask this court to reverse.
Thank you, Mr. Smith. Counsel, Mr. Hollingsworth, would you please present issue 1 on behalf of Mr. Will, Mr. Jones?
Evening, Chief Justice, Your Honors. May it please the Court, my name is Andrew Hollingsworth, and I will be representing the respondent, Floyd, in this appeal. In not asking the prospective jurors content-specific questions, the judge reversibly erred. Under the standard of patriarchate, a judge has to ask questions during the voir dire process that bring to light, quote, the kind and degree of his exposure to the case and parties.
Same question that I asked Mr. Antonopoulos. I expect to give a different answer. Is content-specific questioning constitutionally required? And if so, why should it be constitutional?
No, Your Honor.
It's not constitutionally required?
Well, in this specific context, it is required solely because
Why should it be constitutionally required?
the pretrial publicity of this specific case was unprecedentedly prejudiced. And the vast amount of this pretrial publicity is also unprecedented due to technological advancements in information spreading to social media and such. And this prejudice...
Any reasonably intelligent person, any reasonably well-educated person would have heard this case, seen it, right? Anyway.
You're right.
You've seen it, right? So all the jurors would have seen some content, true, false, in between. So, but I don't understand why it's constitutionally required to ask those content questions to get the defendant a fair trial. That's what I'm trying
prejudicial information could create a certain bias, and without that content-specific questioning in the voir dire process, the bias that is created by this prejudicial.
Play this out, how does that happen? I guess, how does that happen? How does this bias occur? I've not seen.
Well, Your Honor, this bias forms when the prospective jurors spend weeks and months after the initial event seeing news information, videos of the bombings, cited instances that were used by the news of the area of Yellowville. Specifically, in one instance, one reporter falsely cited that the defendant scrawled a rather crass anti-American sentiment into the boat he was hiding before he was captured. Things like this create a sort of bias in prospective jurors that no matter the facts of the case that are presented in court, the defendant deserves the death penalty.
And how does the content-specific question cure that?
Well, Your Honor, the content-specific questions serve to further analyze what specific information the prospective jurors have been exposed to, and then to what degree this content they have been exposed to can further allow the judge to disseminate any type of impartiality, especially in cases where we see the Yellowville mayor even speaks out on live television saying that he deserves the death penalty. This is a very respected man in the community, and he's actively speaking out.
So they say, they were telling us it doesn't matter. It could be a shot. It doesn't matter. Do you agree with them when they said it doesn't matter that it's a death penalty case for this type of question?
Your Honor, I wholeheartedly disagree with that.
Why?
This is solely because if we are to put this man to death, it should not be on the basis of any pretrial publicity that is prejudicial towards the defendant. It should solely be based upon the facts and evidence presented in court. And when the prospective jurors were not asked this content-specific question, the judge has essentially handicapped himself, put himself in handcuffs, in that he cannot, to the extent that a capital offense like this requires, assess whether the jurors have been exposed to biased information that could lead to
So
impartiality.
there should be two standards, one for death penalty cases for what's a fair trial, one for non-death penalty cases. That's what you're saying. Two different constitutions, if you will.
Your Honor, I'm not saying that there should be an explicit difference in the type of voir dire process or content-specific questions. I'm saying that it's something that we should greatly take into account, especially in a situation like this where there is unprecedented media coverage. This is the largest terrorist attack since 9/11 in the United States. Just given that fact, of course there's going to be prejudicial information put into the media, and this could lead to a specific bias within the prospective jurors that the judge would fail to realize. Moreover, I'd also like to point out that in not asking a content-specific question, the judge is putting a very great deal of faith in these prospective jurors in their ability to assess their own bias.
So ultimately, you have to do that, though, right? I mean, we don't have a polygraph test. If there was a magical truth-telling machine to hook up to these folks, we've got to rely if they're willing to tell us the truth. That's what the term means, is we're asking them to speak the truth to determine whether or not they're going to be fair and impartial. They've made multiple representations, over 100 questions. Why are the advocates for the government wrong when they say this judge did plenty? I mean, he really did an extensive job of vetting these jurors. They answered the questions correctly, and why shouldn't that be enough in this case?
Your Honor, with this case specifically, we have to consider the fact that the judge is the ultimate determiner of whether or not he believes that the prospective juror is impartial. The juror can tell the judge, I am impartial, I will be able to assess all the information in court and not based on my own merit. That is true, yet I would also like to note that there are many instances in which a prospective juror would try to conceal the fact or may even be unaware of their own bias. These instances could crop up in certain situations when one considers the fact that in Yellowville, where the trial was held, there were many connections to people affected by the bombings. You have to think over 100 were maimed, 3 were killed. Some
Those questions would have been borne out by the questionnaire, correct? Do you have any connection to anyone that was injured as a result of this, right? I mean, they would have known that anyway. Asking them what they heard about the case, that's really bearing on that. What I would like to know is, I think Tokolos has indicated that the ultimate question is, can they set aside anything that they've seen and judge the case solely on the evidence that's presented? Do you not think that that's the standard? And if so, why do you think that we should expand the standard?
Your Honor, I would agree that is the standard, but in this specific context, we have to consider the fact that there would be instances in which someone would attempt to possibly conceal their own bias, or like
As
I
a
mentioned.
judge who is supposed to be judging the credibility of the witnesses, isn't that his ultimate responsibility?
Yes, Your Honor, it is his ultimate responsibility, but the judge would also be able to assess this dynamic further if he were to allow content-specific questions. For example, if a prospective juror had not seen as much of prejudicial information, for example, you could have some type of extreme blog post or anything of that matter, the judge would be able to further assess whether or not that bias is present.
So is the heart of the matter here that it's a death penalty case, and so we need content-specific question? Is it that it's high profile, that there was a lot of publicity, or is it that there was prejudicial information in the media coverage? Which one of these is raising the need for content-specific questions?
Your Honor, I'd like to point out that under the precedent set by Patriarcha, it explicitly endorses the ABA's Section 3.4 of standards related to fair trial and free press, which explicitly reads, questioning shall be conducted for the purpose of determining what the prospective juror has read or heard about the case and parties. I believe that is significant. We would contend that that is significant enough precedent and legal authority to state that.
So the ABA standards are now precedent?
Well, I'd like to rephrase not precedent, but a decent enough.
Guidance.
Yes, Your Honor. The bias in these prospective jurors would be better assessed through content-specific questioning because the judge would have more information on each specific juror, on their specific news habits, on their specific readings. I understand that because the trial was still held in Yellowville, you have to consider that the participants or the prospective jurors would have received more and more.
Would the venue change, had that been corrected, would you still have an argument that content-specific questions?
Your Honor, I would say that only because this is one of the largest terrorist acts in the United States since 9/11, and culturally, since 9/11, terrorism has been a very, very touchy subject for the United States. And moreover, in this specific case, the judge promised the defendant an intensive and thorough voir dire process, which one could argue he did make, but we would contend that he didn't in excluding these content-specific questions. And the judge, in a sense, dulled his ability to understand whether the bias was present or not, because he did not fully understand the scope to which the prospective jurors have seen this information. Under Patriarcha, we can see that the standard was not met. The standard for Patriarcha was not met. The Supreme Court is not beholden to Patriarcha, although in this case, because of the numerous citations for prejudicial pretrial publicity, one would hope that the Supreme Court would apply this Patriarcha standard to this case. Mainly because
Has it been held to apply to state court context?
Could you repeat that question, sir?
Has patriarchate been held to apply in the state court context or in the federal system?
Your Honor, my time has expired, please. The patriarchate has been applied in only the state context, although in the context of the trial, I believe it would be only, it would only be appropriate for the Supreme Court to apply the same standard as like I said, the prejudicial pretrial publicity was vast.
One more question. I mean, patriarchate was not the death penalty case, correct?
Yes, Your Honor.
Thank you, Mr. Hollingsworth. Mr. Goodwin. Mr. Chief Justice, and may it please the court, on September 11th, 2011, 10 years, on the 10-year anniversary of the greatest terror attack in U.S. history, Green Jones, my client's brother, murdered 3 individuals. In what was a planned robbery, Green, after
Your client was convicted of those murders. That's correct.
sorry,
Your client was convicted of those murders.
my client was not convicted of the murders in Tocqueville.
Oh, I was talking about the case of violence.
Yes.
Yeah, I was confused. I thought you were saying your client was convicted.
No. Green then murdered those 3 individuals, and Aqua was brought in to help clean up the evidence of those murders after a robbery gone wrong. Do we really reliably know that? Your Honor, we do. There's no reason to believe that Aqua's evidence is incredible. The government itself uses that evidence, and my opposing counsel points to footnote 24 of the record, and it's quite unclear on the issue. It says that Aqua and Green found the victims and then, quote, who were ultimately murdered. That doesn't exactly paint them in similar lights to say that Aqua and Green were both murderers or either or, so we must trust Aqua, who was the only person who came to testify about what happened that day.
I agree with Justice Goff. Why do we trust Aqua? I mean, he's telling the police what he wants to play. Some other dude did it. I was there. They didn't do anything. We hear that all the time. So how do we know, to answer Justice Goff's question, how do we know he was telling the truth? How do we know that's credible evidence?
Well, Your Honor, I guess we suppose we don't, but
For your client's sake, you know it was credible, right?
certainly.
Go ahead. For your client's sake, you're hoping it was credible, correct?
I mean, yes.
So the opposite argument could be made, correct?
Yes, but the government itself, in that affidavit, agreed with Aqua, or at least believed the truth of Aqua's arguments.
So tell me what the probative value of introducing this evidence would have been. Tell me your argument. How do you tie this that he was influenced by his brother?
Well, Your Honor, and that's kind of right at the heart of this, the mitigation defense put on, that was hoped to be put on by the defense, relies on the fact that Blue believed and was scared of his brother because of these acts that his brother had committed 2 years previous in Tocqueville. Had he not been scared of his brother, who had murdered someone, and then in Aqua's words, when he was felt like he had nowhere else to go, Blue feels the same way. In this case, he felt that he had nowhere to go after his brother had pressured him into committing these acts at the Yellowville bombings. And that I'd like to move to the evidentiary standard in this case, and that mitigating information, especially in death penalty cases, need not be admissible under normal evidentiary standards.
So how many mitigators were proffered to the jurors in this case? Do you know that? Is that in the record?
I believe there were 6 pieces of particularly mitigating evidence that referred to Green's character and the effect that it might have on Blue. So the kind of weaker version of the mitigation defense put on at trial was that Green had radicalized Blue first, and that in Chechen families, older brothers generally get deference over the younger brothers. Green occasionally broke the rules at his gym. He was sometimes argumentative at his mosque. He yelled at a store over a halal turkey.
It's a bad dude, right?
Yes.
But what evidence do you have that, I'm curious, did your client testify during the mitigation phase?
He did not.
He didn't, so he clearly would have been the best evidence in that regard, correct? That my brother influenced me, jury believed or disbelieved me, but we don't even have that, do we? I mean, clearly he's got a right not to testify, but that would have been the best evidence, don't you think?
Yes, Your Honor, we could hear directly from Lou that he felt pressure. That might be more convincing, but that certainly is required when the evidence would clearly show and the defense would put on that he was. It's not necessary that my client waive his Fifth Amendment right to not testify at his own trial. Under those kind of weaker defenses, 11 out of the 17 charges brought in the district court, no death penalty was brought on those. There's no reason to believe that this further evidence that his brother was a murderer.
So the judge rules that this evidence is coming under the way you want. How would that evidence be presented? Who's the witness you would call? I mean, what would this look like? I don't even see how this would, what would happen in a trial. I mean, who would get on the witness stand, raise their right hand, and say, this? Brother's dead. Okay? We're done here, right?
No, I think
How does this come into evidence? I mean, let's say that the judge is wrong, but hey, you get your new trial. What are your new penalty phase? How are you going to, what's this going to look like in court?
Your Honor, you would likely bring in the FBI agents and the local police that Aqua had testified to kind of.
Tell his side of the story, right? This is what Aqua told me. Is that not hearsay? Or is that above your guys' paper right here? Right? Out of court statement on proof matter asserted. That's hearsay. That's not allowed in a criminal trial. How do you get past that? You have to have an exception. That's the exception.
Well, Your Honor, the evidentiary standard when it comes to penalty phases is lower than would be normally admissible otherwise in the regular guilt phase.
So you're saying the rules of evidence didn't apply then in the mitigation or the death phase of the case?
No, not that none of the rules apply, but they don't apply to the same level. It would be.
Mr. Smith talks about the ability of the government to cross-examine. Who are they going to cross-examine in this case? Right, brother's dead. Guy that says brother killed 3 other people's dead. Who are they going to cross-examine? Don't they have that right to cross-examine the witnesses the defense brings?
They do, but I think kind of turning it. This case doesn't rest on whether or not Aqua's evidence is factual or not. It could be wholly made up. The fact is, Blue believes that it's true. Blue believes that his brother, 2 years previous to the Yellowwood bombings, had committed jihad and killed these 3 people. Simply because of Blue's belief in the veracity of this testimony is what led him to follow his brother.
Mr. Goodwin, is it a big problem for them that the Brady violation occurred, that you didn't get the evidence, you didn't get the 302, you didn't get the recording? Isn't that a big problem for them?
Yes, Your Honor, this court has ruled in Kyle's v. Whitney that there is an inescapable duty to disclose important material evidence. And as I've stated, material evidence includes information that might create, quote, a reasonable probability of a different outcome.
So if they got the evidence, if the defense got the evidence, they might have figured out a way to get something in there that would be mitigating, but they never got it. Is that a problem?
Yes, because my client's defense was never able to get the 302 reports.
Does it say the United States government, the United States of America, that a trial judge looked at it and said, yeah, this is material, this is great? Does it save them?
No, Your Honor. The abuse of discretion standard is a high standard, but any misapplication of the law immediately proves abuse of discretion.
The judge abused his discretion in not taking into account Tiles v. Whitney nor Coe v. Bell, which said that material evidence is mitigating evidence. There's no doubt that this evidence that his brother had murdered 2 people, or 3 people 2 years previous, wouldn't have any effect in mitigating his brother, in mitigating my client's guilt.
Because this is a death penalty case, it's just a penalty phase, should we expand our sort of definition of what we let in the sentencing phase? What sort of testimony and evidence we let in the sentencing? If the same question I asked them, so it's a shoplifting case, we only allow this much evidence, but in a death penalty case, we allow this much evidence in the sentencing phase.
In general, yes, Your Honor, I think we can. I think when it comes to the greatest possible penalty any government could impose, it's necessary that you loosen the evidentiary standard than you would in a case where that isn't on the table.
Two different constitutions. Two different constitutions. One fair trial for shoplifting means one thing, fair trial for a case of death penalty.
I don't believe that creates 2 different constitutions.
Okay. Why not?
Well, I believe that when you're dealing with, I mean, as I stated, the worst possible punishment that you could impose on anyone, I think it's reasonable to say that there's a kind of certain level, or kind of a lower level of evidence of the evidentiary standard that is necessary, and this court has found that way before. This court shows a lower evidentiary standard, particularly in the penalty phase, in death penalty cases, that it would not allow in the penalty phase of not death penalty cases.
You know, these death penalty cases go on forever. Kind of tired of it. Is there any interest that we would have in this finale? I mean, you know, let's say we agree with the Court of Appeals, it goes back, and the penalty phase, and another complaint, it goes back again, and another complaint, and another one. You know, 30 years later, the victim's family, we're still waiting for justice, and here we are, here we're sitting. Is there some interest in finality here that at least is a compelling interest that should outweigh your client's interest?
There may be kind of a valid, legitimate state interest in wanting to have the finality of getting.
So the balance.
Well, I think, Your Honor, I think the 6th Amendment's guarantee of a free trial, or of a fair trial, and that you won't be deprived of life without due process, makes quite clear that simply the argument that the state wants to get it over with isn't a strong enough argument to allow the state to essentially kill my client.
You also be deprived of liberty without due process, so why would we hold the death penalty case to a different standard than the shoplifting case?
Your Honor, I don't think that the Bill of Rights would require that, let me get this right, would require that setting a different standard for a different possible penalty would create a difference in due process. I think because you're dealing with a harsher penalty, there's kind of a higher level that you have to reach for due process. For all things, we ask that you affirm the court rulings.
Mr. Smith, your vote.
May it please the court. Justice Minkler, earlier this evening you asked my co-counsel how much weight should we give the district judge. And ultimately that is the reason why we asked this court to side with the U.S. government. The answer is significant deference. And that matters on both the content questioning side of this case and the Brady and mitigating evidence side of this case. The district judge made a reasonable decision according to this court's precedent. The Court of Appeals second-guessed it on something not constitutionally required under Moot-Min. And just as a reminder, Patriarcha was a pre-Moot-Min decision before the Supreme Court had announced that content-specific questions were not required. Justice Alteis, I believe you asked the opposing counsel about where's the direct evidence in this case? Where's the direct evidence that green forced blue? And again, the answer is there is none. Not only did Blue not testify on his own behalf, there's no journal where Blue wrote that he felt forced by Green. There's no friend or family member saying that Green forced Blue into this. There's nothing. And
Is Mr. Goodwin right? Because he said that at the sentencing phase, well, definitely just we should let this evidence in and make a decision there. So what's the harm in letting this evidence in? I don't see the prejudice. I still don't see the prejudice. I see some probative value. I got trouble by out evidence, but what's the harm?
So, Your Honor, the harm is ultimately why the defendant lost in Sampson. And the harm is the risk of confusing the issues, of the risk of creating a mini trial of an unsolvable triple murder where all available witnesses and perpetrators are dead. An unsolvable murder in the middle of a trial for one of the greatest terrorist attacks in American history.
But that's in the film phase, right? That's after the trial. It's not a trial within a trial. That's in the film. It's set, right?
That's correct, Your Honor.
That matter?
I see my time has expired. May I briefly conclude?
Please answer the question.
Yes, so if this would be a mini trial of unanswerable questions within the sentencing phase of a different trial. The district court judge made no error of law, and so we shouldn't even be here tonight. We ask this court to reverse.
Thank you, Mr. Smith. Well, counsel, we thank you for your excellent oral advocacy. We are going to recess briefly to take the matter under advisement, and then we'll return to the courtroom to render a decision.
All rise.
Thank you. Please be seated. Ladies and gentlemen, friends and family in attendance, would you please join my colleagues and I in giving a round of applause for all of us. What I think we would like to do is just take a few moments and give you some remarks and feedback about what we observed today. And I'm going to go ahead and exercise my privilege, I guess, as the chief, and go last, if that's okay. I'd love to hear, Professor, you know these folks better than the rest of us. I'd love to hear your thoughts.
Sure. I do. I've had all of you in at least one class, and so it's great to see you up here on stage competing really well. This is a difficult case. It's a complicated one. It's a technical one. It's different from the usual moot court cases in some ways. And I really appreciated how well prepared you all were and how well you handled some difficult questions about really big issues.
You want me to go next? I'll just reiterate what the professor said. I was just quite honestly stunned at how well you guys handled questions from us. I mean, I do this for a living now, and you were so much better than a ton of lawyers. You were also facing what is called a hot bench. We were all as well prepared as you were. I know Josh and I both cheated and read the appeal, the actual opinion in this case, in addition to all the materials you had. So we knew this case fairly well, and that really intimidates a lot of oral advocates at times when judges start peppering them. I've seen it before they even say their name, vote right at you. And that did not faze any of you. A couple of you thought, composed yourself, which I thought was incredible, before you had a tendency to say whatever's on my mind and can get you in trouble. So anyway, I was very impressed with how you handled the questions. And obviously at this stage, you guys know the case forward. So that was, and the last thing I will say was I was also impressed at how you handled questions that you may not have known what the actual answers were, just because it was a little too complicated. I agree with the professor. Some really complicated issues and definitely litigation that were involved in this case.
Yeah, it was, I was impressed with all four of you. Your level of preparation was amazing. I know how hard it is to be a student here and all the competing interests and all the things you had to do, so to spend the time that you obviously spent on this to get ready. You can tell the preparation was amazing. I was also impressed with all four of you, your level of formality. It's taken for granted, but for college students to understand in a moot court that when you're arguing at an appellate level, to be more formal, to stand, to not speak until you're called upon. There are different ways to behave in front of an appellate court versus a trial court, and for college students, it's just amazing. It's amazing that you were able to figure it out. And the other thing I'll compliment all four of you on, which, there are practitioners that have done appellate arguments for years and years, and they don't answer the question. The judge asks them a question. The reason the judge is asking the question is that matters to them. They're not trying to trick them. They're not trying to make them look bad. It's the answer to that question is going to impact how they rule. And a lot of advocates won't answer the question. They'll try to persuade or something. And all four of you, every time a question was asked, your first response was yes, no, and you answered the specific question asked. So you show a level of ability and maturity far beyond your years. And I was very impressed by all.
Thank you, Josh. I'm really just privileged to be here with my colleagues tonight. Professor, I just highest compliments because a really good political science undergraduate professor shapes you like nothing else to become an attorney, to become a good attorney. What you learn about the interplay of people and complex relations that we have to live together by consent under a set of rules is something that you pick up here and will always remain with you. So I really so respect what you've done here, and it obviously shows values for young men. Judge Alteis, I've known for about 5 or 6 years, and he best trial lawyer in Indiana when he came on the Court of Appeals, and he is really paying me high compliments when he says what he does, and it's true. And Josh, I don't know as well, but to become the United States Attorney in the population center of the state is a big deal. And so I have confidence that there's probably at least another one among the four of you, but that's coming from the real deal, so take it in. We've got a really hard job. When I got on the Supreme Court, my colleague Steve David said before, he said, Chris, if you get the job, remember, it's subjective. And if you don't get the job, remember, it's subjective. And it's subjective, okay? Because you're a really good lawyer if you are among your colleagues. You are outstanding. And we all have days that are better than others, and you should be proud of what you've done, no matter who comes out on top. Mr. Antonopoulos, you had to go first, right? That's a tough thing to do. You did it well. I agree with my colleagues. You responded very well. Mr. Smith, you had double duty, right? You came up here, you pivoted just as you needed to pivot. You were very quick on your feet. Mr. Hollingsworth, I thought you just did an excellent job stepping in and being an advocate for someone who's just charged with the most horrific crimes. And Mr. Goodwin, you really did the same thing. So hats off to all of you. As I said, there can only be one, and so tonight's winner and the winner of the 2021 Moot Court Top Advocate Award here at Wabash College is Cooper Smith.
join the panel in congratulating Cooper and all of the participants this evening. We also want to thank our judging panel for their service this evening. We have presented each of them in the box that they see in front of them a gavel as a token of our appreciation. Please join me in thanking them. For the past couple of years, we've also offered a second student award at this event. It's called the Floyd Artful Advocacy Prize, and it honors the memory of Douglas V. Floyd, a Hamilton County lawyer, remembered by his colleagues as an artful advocate of causes he believed in. The winner of this is not only a successful advocate, but also a kind, tactful, and principled advocate. As lawyers might say, he succeeds without scorching the earth. What we seek is not only winning qualities, but also a winning disposition, someone who can take the heat with a smile. This gift is funded by gifts from Doug's colleagues, friends, and family given at the time of his death in 2001, and Doug's wife Lisa and his son Riley, Wabash class of 2013, established the prize in 2019. Selection is made by members who organize Moot Court, and the award may go to any of the 4 finalists. We are happy to award the Floyd Artful Advocacy Prize for the 2021-2022 school year to Vasilios Antonopoulos. At this time, we will adjourn. You are welcome to celebrate the participants in Littell Lobby, which is right outside the doors in the back. Again, I would ask our participants and anyone who was involved in Moot Court as a judge or a participant in the preliminary round to please come on stage for a photo. But otherwise, that concludes our event this evening. Thank you so much for joining us.
I hope so.